Hello, welcome to American Government. Today we're talking about Chapter 5, Civil Liberties. We're talking about the Bill of Rights, the first 10 amendments to the US Constitution. 3 points to make today. First of all, we'll define civil liberties. What are they? What do they mean? And where are they located? Where can you find out what your civil liberties are? Second, we'll talk about freedom of speech, one of the most important of our civil liberties. Third, we're going to be talking about limits on civil liberties and free speech. The civil liberties are contained in the Bill of Rights. The Bill of Rights are the first 10 amendments to the Constitution. I'm talking about 5 of them here today, but there are 10 altogether, and they are something that was added to the Constitution. Remember that the framers in 1787 gathered, they wrote the Constitution, which had 8 articles, and then they sent it out to the states to have them look at it and ratify it. The Constitution required 3/4 of the states to ratify the Constitution before it could take effect. It also requires 3/4 of the states to ratify any amendments to the Constitution. Well, you may remember the Anti-Federalists were concerned about the power of the central government. They were concerned that the central government would have too much power, and so they banded together and said, we will not ratify this Constitution until it protects the civil liberties of the people of these United States. Some of the states had already ratified the Constitution as it was, and so that meant that they had to figure out a way to add in these protections of civil liberties while keeping the original Constitution. So James Madison was given the task of writing out amendments to guarantee civil liberties. He wrote out 12 of them based upon English civil law and the idea of the Enlightenment. And they sent these around. 10 of them got ratified by the states. 3/4 of the states, as 9 states of the 13 agreed to those 10 amendments, and they became part of the Constitution and the first 10 amendments, the Bill of Rights. The first of these is freedom of speech and freedom of religion. That is, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. Second Amendment is the right of the people to keep and bear arms. The Fourth Amendment protects people from unreasonable searches and seizures. That is, that no warrants shall be issued except upon probable cause supported by oath or affirmation. That is, the police have to go to a judge to get a search warrant. They have to demonstrate probable cause for searching a house, a property, a person, thinking that they are engaged or did engage in illegal activity. The Fifth Amendment says that you cannot be tried twice for the same crime. It also says that you do not have to be a witness against yourself. That is, you can take the Fifth Amendment if you want to. If you're forced to testify under oath, you can plead the Fifth and refuse to answer questions. The Eighth Amendment says that there will not be excessive bail or punishment, and there will not be cruel or unusual punishments inflicted for conviction of a crime. If you are in the criminal justice major or you're interested in these kind of things, keep in mind that the civil liberties have a huge effect on how criminal justice operates in this country. One of the things it does is it protects people against search and seizure, illegal search and seizure. Police, as I said, have to have probable cause to do a search. Otherwise, evidence that they find can be excluded by courts and denied, so the prosecutor can't use that evidence in a criminal trial. The Bill of Rights also guarantee that you have the right to a speedy trial and the right to representation in your trial. Ernesto Miranda in 1966 was arrested and as a suspect of a crime that he apparently did not commit, but he was arrested as a suspect, taken down to the police station, held in a questioning room for some time, berated by the police, and finally at the end of the night, he confessed to the crime. He went to trial, he was convicted. But on appeal, it turned out that the judge found out that he had not been provided with an attorney and that the police had used suspect evidence to convict him in the first trial. It was thrown out, the conviction was overturned and thrown out. And that led to police forces now being required to read people their rights, or their Miranda rights, when they arrest somebody, saying that they have the right to remain silent, they have the right to an attorney, and if they can't afford one, they'll be provided with an attorney. this helps protect people against police abuse or being forced into confessions for crime they didn't commit without consulting with an attorney. Freedom of speech is one of the rights that Americans hold most dear. If you ask students or anybody on the street, basically, what's the most important of the 10 amendments, they will generally say the first one, protecting freedom of speech. Americans have a great protection of freedom of speech, much more than really any other country in the world, including democracies in Western Europe, all of which have some kind of restrictions on speech. But in the United States, there are no legal restrictions on your speech. There are certain kinds of speech, 5 types of speech, I should say, that are not specifically protected by the First Amendment. That is libel, which is telling a lie about somebody with the intention of harming them professionally or personally. Obscenity has not been protected by the First Amendment. It is increasingly protected by the First Amendment, but in the past, it was considered a question of, was there some redeeming social value in, say, pictures of naked people or pictures of people having sex? Those are considered not to have any redeeming social value, and so were declared illegal. Symbolic speech, which is political speech. That is, it's political advertising or an intent to persuade or incite somebody into action, violent action in particular. This kind of speech is also not protected under the First Amendment. That is, this is speech that's meant to do harm. Commercial speech is also not guaranteed under the First Amendment. You don't have the right to say just anything you want to about a product you're selling. You cannot lie about a product in order to sell it. That's not considered free speech. Finally, hate speech is a relatively recent kind of speech that has developed, that is a speech that attacks a person or group on the basis of attributes such as race, religion, ethnic origin, national origin, sex, disability, sexual orientation, or gender identity. And so speech that it is meant to harm people is not protected under the First Amendment. You've heard this notion that you can't shout fire in a crowded theater. Why not? Well, this goes back to a trial of 1919. Charles Schenck, who was an anti-war activist, was handing out anti-war posters, leaflets during the war, during the First World War. He was arrested. Excuse me. And he was put on trial under the Espionage Act of 1917 and the Sedition Act of 1918, saying that he was trying to harm America's war effort. Schenck went to court and claimed that this was his arrest was a violation of his freedom of speech, that he had the right to oppose the war, true enough. And he said that he had the right to hand out leaflets opposing the war, true enough. The question became then whether his doing so was in some ways harming the United States and its citizens, or whether it was putting soldiers in harm by trying to get people not to enlist in the military. Judge Oliver Wendell Holmes, down on the lower right side there, said that the most stringent protection of free speech would not protect a man falsely shouting fire in a theater and causing a panic. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to protect, to prevent. And so clear and present danger, that meant that you cannot do something that is likely to put somebody else in danger. Clear and present. You yell fire in a crowded movie theater when the movie's playing, people are going to jump up and try to run to the exits, and they will get harmed in that effort. People will get stampeded, people will get stepped on, stomped on, injured in other kinds of ways. And so if there's a clear and present danger, your civil liberties can be suspended, is what Oliver Wendell Holmes is saying. And so the implication of this is that not just your First Amendment rights, but your rights under any of those 10 First Amendment, of those 10 amendments, the Bill of Rights, that can all be suspended if there is a clear and present danger. The courts wrangled with this for some time, and they decided that clear and present danger was too vague of a term. What is a clear and present danger? Something that seems like a clear and present danger to one person might not seem like a clear and present danger to another person. And so the courts wrangled with this. In 1969, they had another case that came up to them, the Clarence Brandenburg v. Ohio case. Ohio had passed a law during the Cold War as an anti-communist war originally, and that was fine. But in the 1960s, it was applied in a totally another case. That is Clarence Brandenburg, who was a member of the Ohio Ku Klux Klan, was arrested under the Ohio criminal syndicalism statute for basically calling for violence against African Americans. The Ohio statute prohibited speech advocating the duty, necessity, or propriety of crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform. You can see that was written basically against communists, but the Ohio state arrested him under that law, put him on trial. Supreme Court came out and agreed with Ohio, basically saying that the constitutional guarantees of free speech and free press do not permit a state to forbid or proscribe advocacy of the use of force or of a law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. And so the Supreme Court narrowed it down some to say that it's not just a clear and present danger, it is imminent lawless action. What is imminent lawless action? Imminent means it's going to happen right now, immediately. That is lawless. That is, it's going to involve a crime, or it's going to involve a violence against people, or destruction of property, or some other kind of criminal act, and that it's calling for action. That it's not just speech against a group of people, or calling them names, or insulting them in some way. This is calling for action now that is illegal. And so that was the court decision. Now, that's pretty much the definition that we've been working with since 1969, is that your free speech is limited by that consideration of whether you're harming somebody or calling for somebody else to harm them through various actions. That brings us to the third thing, the limits to civil liberty. As I mentioned several times here now, it's that principle of harm is what the Supreme Court has used to define the limits of our civil liberties. That is, your civil liberties, my civil liberties, exist up to the point at which we harm somebody else. You do not have the right to harm another person under the Constitution. Physically or verbally, you do not have that right. You do not have the right to do things that knowingly and willfully cause harm to another person or group. You might say something that insults a person if you didn't intend it as an insult, or you didn't know it was an insult. That's one thing. If you know that it's an insult, you know that it will harm them, and you do this, then your civil liberties don't protect you. This is true of limits of free speech, limits on free speech, such as calling people by racist slurs or sexist slurs, calling for violence against people because they are members of a certain group in society, calling for imminent lawless action. Think about the mask mandates. There's been a lot about the mask mandates in the last year and a half. People saying that the Constitution guarantees their right not to wear masks when they go out in public because they don't want to wear a mask. And so they say, well, I'm guaranteed, I have freedom under the Bill of Rights. That's not actually true. People have the right not to wear a mask as long as they are not putting somebody else in imminent danger, that clear and present danger. And so the person not wearing the mask doesn't have the right to put people in danger at a time when the spread of disease is virulent, and there's a very good likelihood that a person not wearing a mask will be spreading the disease. Whether anybody's going to catch that disease or not is not really the issue. It is that the person is subjecting people to potential harm, and therefore civil liberties don't apply in that case. All right, I'll leave it there. Thank you for coming today. Let me know if you have questions, and I'll look forward to seeing you